name is Brittany Sherman. I'm the CEO President for the Morgan Hill Chamber of Commerce. The Chamber of Commerce, in coordination with the City of Morgan Hill, John Lang there, thank you for coordinating with us a second time again. We actually had one of these about 1.5 years ago when some of these fictitious lawsuits were abundant in our community. We've now seen another uptick in them, so we figured it was about time to come and kind of do a refresher course. A lot of businesses don't understand the rights that they have. They don't understand the process. They don't understand where they can go for help. So this is meant to address those in many different areas. So I will go ahead right now and let the speakers kind of just introduce themselves, and we will kick it off officially with Josh. So Jim, would you like to go first? His name and
my name's Jim Wilson. I'm sorry, was it Josh or?
No, go ahead, Jim. Go ahead.
My name is Jim Wilson. I'm a property owner in Morgan Hill for the last, my family's been here for 80 years. And right now I'm being sued, so.
Thank you. Naomi? Wait, I can't hear you, Naomi. You're muted.
Oh, hi. Can you hear me
Hi.
now? Hi. My name is Naomi Hayashi. I'm a farmers insurance agency owner, been an agent for 26 years, and I'm here to give you some help and then some advice as to what's going on in our community as we speak.
Thank you, Naomi. Eric?
So I'm Eric Blomquist. I'm the building official for the City of Morgan Hill.
Thank you. John?
Hi, good morning. John Lang, Economic Development Manager for the City of Morgan Hill.
All right, and I'll let Josh introduce himself and start us off with the legal discussion.
Great. My name is Josh Jachimowicz. I'm an attorney. I live in Morgan Hill, and I've helped a few business owners out, handled a few ADA cases. I am not an expert by any means, and I do need to make sure to point out that none of the information that I provide today should be construed as legal advice. When this is over, if someone wants to give me a call, I'd be happy to talk to them specifically, but can't do that in this context. So I will kind of launch into a talk, give very, very general overviews of why these cases happen, and then how they're dealt with, and some ideas about what we can do as both building owners, tenants, and hopefully as a community to try to combat this issue. I will start off by saying that I am generally a plaintiff's attorney, but I do not handle plaintiff side ADA matters. The ADA in general is a good law. Access for everyone is fair and it's good. Unfortunately, lawyers, especially lawyers in California, where we have approximately 46% of the national ADA cases occur in California, have taken advantage of a system set up to protect disabled individuals and turned it into a cottage industry. And that's why I've tried to get involved, tried to do what I could to help out the community that I live in. So the ADA has very specific requirements for access to public accommodations. I obviously don't have time to go through them, but they're all accessible for any and all small business owners that are listening. There is specifically an ADA guide for small businesses that you can go on the internet and take a look at. But generally speaking, the way these issues come about is a disabled person attempts to access in some way, shape, or form a business and cannot. And sometimes that means that they can get in the door, but they can't get to the bathroom. Common issues that we see are, well, realistically right now, not actually issues. Walkway space, counters and table heights, the number of seating arrangements, access ramps, coming in and out, doors, ability to get in and out of buildings. That's a lot. Those are kind of the major issues. There's a laundry list of minor issues that are always brought up in these cases. But those are the big ones. I will also say that parts of this, because I'm a lawyer, I'm able to speak out of both sides of my mouth. So there's advice for owners of buildings and there's advice for lessees, and they're not necessarily the same and they're not helpful to one another, but I'm going to give it anyway. And I said advice. If you're a lessee, the first thing you want to do is check your lease and see if it speaks to any ADA issues. Most leases don't, some do. The goal being that if something happens, you can look to the owner of the building or the lessor and say, help me out here. Lessors, you probably want to look at your leases and make sure that the individual owners, tenants are responsible for the insides of their businesses. And that's generally how this goes. Very generally speaking, inside the business is the business's responsibility. Outside, walkways, sidewalks, parking access, that's the property owner's responsibility. A lot of times a plaintiff will claim issues with both the property in terms of parking and sidewalks, ramps, and individual businesses, and do it all together because they know that they want the property owners involved in these lawsuits. That's generally where the deep pockets come from. When I handle a case, I always try to, if I can, get the property owner and the business owner to work together to kind of spread some of the financial burden, which unfortunately, more often than not, that is what these cases come down to, is dollars. I'll get into that. Something that a business, other than checking your lease agreement, if you're both building owner and a business owner, can check your insurance policies, and I'll talk more about that at the end and maybe segue to Naomi, but check your insurance policies and talk to your insurance agents about getting coverage for ADA violations. I don't know if there's riders. Some business liability policies cover these as occurrences, but that's also something to look into. And finally, as a business owner, something you can do is get what's called a CAsP report. And as I'm talking, I'm blanking on what the actual acronym means. So look it up. Basically, that's an inspection report done by a certified inspector who will go through your property or your business and say, here's all the things that are in violation of the ADA, and here's a report, and here's how to fix them. Now, in an ideal world, that means, okay, you get a report, there's 20 items, you fix all 20, and you're immune from these kinds of issues, and that's not true at all. For a couple reasons. One, CAsP inspectors aren't perfect, they can miss things. Two, the ADA is a law, it continually changes. Sometimes the requirements change, and you've gotten a report and 30 days later there's a new requirement that's not in the report, and a plaintiff comes by and takes advantage of that. So it is helpful. I think it's necessary. It seems to be necessary in our area because this is now the second time or third time that businesses in the area have been hit. So if any business owner asked me, should I do this? I'd say yes, there is an expense to it. And unfortunately, sometimes the things that are found are very expensive to fix. So at that point, you would have to make a decision as to whether or not you wanted to make that fix or wait and see what happened. The other advantage to having that report is it can have the effect of lessening any fines levied against you or claimed against you in court. Because there are exceptions to the various laws that say that the fine under the law is reduced if there's a CAsP report prior to the issue and there maybe some changes weren't made. So those are some kind of proactive things that can be done. I will talk about a couple more toward the end. The next question generally is what do I do if I have been sued? The first thing you do is call a lawyer. In state court, you have 30 days to respond to a complaint. In federal court, it's only 21 days. These cases are almost exclusively federal cases because in California, under state law, we can move to have individuals who file lots and lots of lawsuits deemed vexatious litigants, and it makes it a lot harder for them to file these lawsuits. The federal courts don't have the exact same thing. The courts themselves can do it, but it's a lot harder to get done. So generally speaking, these cases are filed in federal court, excuse me. That gives you 21 days to respond. So the first thing to do is call a lawyer. Doesn't have to be me, it just needs to be a lawyer. The worst thing anybody can do is ignore it. Not any lawsuit, really, but these ones especially. Very generally speaking, under federal law, your fine is $4,000 for every claimed visit that the plaintiff made. And the key word is claimed. In order to file a complaint, you, as a plaintiff, simply need to say, these are the things that happened, and I promise they happened. You don't have any burden of proof at that point. The lawyer has some rules. You couldn't file a claim I knew to have no merit, but if the lawyer believes that the individual had attempted to access the business over the course of 6 months 4 times, they put that in their complaint, and that complaint gets filed. And whether or not that's true is a separate matter that needs to be dealt with later on. The problem is that these lawsuits cost money to defend the lawsuit, unless you can get an insurance company to cover it and pay for the attorneys themselves. So as I said, it's about $4,000 a visit if it's filed federally and there's no exceptions. There are California-based exceptions that the federal courts may or may not decide to grant you, and that's a lower fine for a small business who can show they've grossed under, I think, $3 million within the last 3 years. So that applies to a lot of small businesses. That does help reduce the fine, but it still doesn't make the case go away. After receiving a complaint and calling a lawyer, you can either let that lawyer take over and do the job. I generally tell my clients as I'm on the phone with them, please go take pictures of any areas that are outlined in this complaint so that we have them and we can look at them. Then the task of actually investigating whether or not the individual had shown up starts. You speak to all your employees, see if anybody remembers an individual trying to come in. Most places don't have cameras, but if you have a camera, get your camera footage to see if there's any ability to show, hey, can actually come on this date. That would be helpful. That is hard because the individuals have 2 years to file these. And a lot of times what they'll do is they'll attempt to access a building or a business, and 6 to 8 months later to a year later, they'll file a lawsuit and say 6 to 8 months ago, back in, I don't know what month it is, so however many 6 months ago was February, January, I attempted to access. And the point of that is to say, hey, none of my employees are going to remember if someone came in 6 months ago. Again, I don't mean to say that none of these cases have merit. A lot of them do, but generally speaking, this is the kind of plan of action these firms take because it makes it very hard to disprove someone attempted to access when no one can remember and you don't have video. And so if you can't prove that they didn't, I have to say, okay, then we have to try to resolve this case as quickly and cheaply as possible. And that's unfortunately, from my understanding, that's how most of us defense attorneys who deal with these cases view these cases, is unless you have lots and lots and lots of money to burn, you need to try to settle these as quickly as possible. Some plaintiffs don't even require that we prove that we fixed the things that were complained of, and they don't have to. Some do, and they tend to be the more upstanding firms that say, hey, no, I want these things fixed before we're going to resolve this case. And in that case, the kind of the same steps we took beforehand, which are get a CAsP report. And it's a little bit different after. You have a choice when, after you've been sued to decide if your CAsP inspector should inspect the entire building or the entire property, or simply inspect the items identified in the complaint. There are advantages and disadvantages to doing those two things, and that would have to be discussed on a case-by-case basis. But generally speaking, hire a CAsP inspector, fix what needs to be fixed, and then start saving money or have a fund ready to try to resolve the case. My experience in these cases is that they resolve for somewhere between $15,000 to $20,000. And that does not include the fee that I'm paid. I don't charge much, but other lawyers do. So, you know, as a business owner, it's hard to hear that, hey, you can get hit for $25,000 to $30,000 expense, and there's really not a whole lot you can do about it, because unless you can afford to get everything brought up to code. That's a very general overview. I know it's not the greatest it's not the most optimistic information, but there are, the last time I did this, there was a movement to kind of clean up the language of the ADA to make it not quite so simple for individuals to file these lawsuits. I do not know the current state of that, either statute change or case law change, but it is recognized as a problem. The question everyone has is, how do we fix it while still allowing for individuals who really have suffered and not been able to access properly, giving them the tool they need to get change. I'm very quickly looking through the Q&A. There's some information. You know, I cannot speak to specific factual circumstances, Mr. Nguyen, so I'm not going to answer that question. Jody Hall is asking if you can be sued twice for the same thing. You can be sued multiple times for access issues, though ostensibly, if you've been sued and fixed something, then it won't be an issue. The difficulty there is that, as I said, the ADA has a very large list of small things that any violation of the ADA can be used in a complaint. I've seen things that the counter height was half an inch off. I mean, there are very technical things that can be used. The practical matter is that these plaintiffs kind of come through areas and they don't hit businesses they've already hit, because one of the arguments that we can make in defense is basically they're only doing this as what's called a tester, which is they just go and see if they can access something. If they can't, they file suit, and it makes it harder for them to do it to more than once to the same place, because then it becomes it brings up other issues for the plaintiff themselves. So they tend not to sue the same places more than once. But technically speaking, yes, you could be sued more than once for separate access problems. Ms. Hall also indicates it sounds like we're 100% at the mercy of random individuals. I'm an optimistic person. I don't think that's completely true, but there is some truth to that. There just is not a whole lot that can be done, and that kind of has led me to what I think the solutions are, which I'll get into not quite yet. Recently, I became aware of a defendant in Morgan Hill whose building is potentially a historical building, and they had questions about what happens in this case. And so I looked into it and I added that to this talk. And even that does not get a business out of being sued for this and being forced to make changes. It does change. It basically lowers the threshold for what has to be changed, because you can't make anybody change anything that would threaten or destroy the historical significance of the property. But the point is, that doesn't mean there are certain buildings where we say, well, this is grandfathered in, quote unquote, and is exempt from ADA. Nothing is exempt. But it does change the what's required. If you're a tenant and you think you're in a school building, speak with the property owner. Try to confirm that if you can, and then at least you know that if a lawsuit comes, then there's a little bit of a lower bar. You might have a better chance of getting out of it, but realistically, the answer is you probably get out of it for a little less money than you normally would have. So, again, this is all very glum, but I think there are a couple of community-based solutions that could work. One, of course, I think the biggest thing that will work is insurance, is getting either an insurance policy that specifically covers these cases, because then you're not paying out of pocket for an attorney, and any settlement, depending on, of course, the terms of the policy, could be taken care of by the insurance company, and the insurance companies have a lot deeper pockets than most business owners. It also, I believe, is potential that these cases will be properly defended. Even if you think your case is winnable or defensible, which it might be, again, the advice that I've always given and the advice that I've heard other attorneys give is, that's great. Instead of spending $100,000 on an attorney to try a case and potentially still losing, you should pay a little bit of money now to get rid of the case. So individually, I don't know that any business should. I don't know that I would ever recommend a business try to fully defend this issue unless it was kind of ironclad, because you're still at potential for a loss. And the problem with the loss is that, yes, you have to pay maybe $4,000 per visit. So the actual damages to the plaintiff are not, generally speaking, very large, but you're responsible for their attorney fees. And that's the real hammer, because these plaintiffs' attorneys know how to make six-figure attorney fees on these cases if they go too far. The insurance companies actually would feel differently about spending that kind of money to defend these cases. And in fact, in the personal injury auto accident realm, they will spend 3 times the amount of money on defending a case as I've asked for to settle the case, if the principle makes sense. So my thought process was, if we can get enough insurance companies involved in these cases, then they'll be properly and fully defended, and potentially these, especially these serial plaintiffs, will start to lose or have the federal courts recognize and not letting these individuals simply file cases anymore by the hundreds. You know, they have to go through some steps to get cases filed. The other solution that I've come up with is essentially insurance, but self-insuring through either the downtown association, having businesses come together and just making a risk pool and saying, okay, we'll all contribute X amount of dollars per month. And when one of us gets hit, we'll use that money to defend. You know, that's, I think personally, as a business owner, I would prefer insurance. But if insurance doesn't make sense, or if it's too expensive, maybe all the tenants in one, instead of having insurance, get together and say, we'll all contribute to a pool, and we'll agree to that pool to defend these. And until the actual ADA changes and the requirements of the law change, I think that's the real way to deal with these, so that the impact on individual businesses is lessened. There's another question about website links. I don't have a specific link. I have a specific individual who actually spoke at the last one of these, who I use, so I'm happy to recommend people. I'll do that. I would prefer to do that offline, but Googling a CAsP inspector, you know, in your area will come up with a list. There's a number of them, and they all know each other. It's a small industry, so they all tend to be fairly competent. But if anybody wants to try to contact, I'm happy to recommend an inspector. I think that's kind of my talk. get a lawyer and try to get insurance. That's kind of there's the summation.
Perfect. Yeah. Thank you, Josh. Really appreciate
So
it.
I'll turn it over to whoever's next.
Perfect. Thank you, Josh. Really appreciate it. I'll go ahead and turn it over to John Lang and Eric.
Good morning. Well, really happy to be with you. Thank you, Josh. So before I do a little Q&A with my colleague, Eric, I just wanted to remind people on the call and maybe viewing this webinar lately, a lot of what Josh talked about is extremely important on the built environment, but recognize ADA, Americans with Disability Act, is not a building code. It's a federal code. So we talk about the built environment, but people are being sued for not accessible websites now is a new thing. So recognizing ADA has a much bigger area of coverage than the built environment. Where we feel the most impact is the built environment, and that's really the purpose of today's call. But just recognize people can be sued for having inaccessible websites. So it really is about access to business. And when you talk about access, it's virtual access, it's physical access. But I just want to put that out as a reminder. I'm really happy to be joined by the city's building official, Eric Blomquist. And one of the things I wanted to have Eric talk about is really what is his role in the city, and as it relates to building codes and ADA, what is your role? How, when people are proposing to build buildings or modify buildings, what's your role in this, and how does it relate to the ADA?
So as the building official, I'm responsible to adopt, interpret, enforce the California Building Standards Codes and other various states' life safety codes. As far as the ADA, or Americans with Disability Act, I mean, that is, as Josh indicated, a federal law. It is not a building code. The building code that we enforce to have the accessibility standards is the California Building Code, Chapter 11A and Chapter 11B. The Americans with Disability Act has it's the 2010 ADA-S, or American with Disability Act standard, which provides accessible standards for buildings, but yet it's not a building code, and we don't actually enforce those. They are very similar to Chapter 11B of the California Building Code, but once again, they're not the same as a building code.
So when you're reviewing documents, you're looking at the local building code, or local adoption of the building code in terms of approving plans or modifications. So it's to that standard. It's not necessary to ADA, correct?
That is correct, because the ADA is a federal law and it's not a building code.
Gotcha. Okay. So, can you tell me a little bit about the role inspections play? So, someone designs a building or is designing to make modifications to a building, and we go out and inspect those buildings. But what is it we're looking for in those inspections?
So, well, let's kind of go back to, we inspect buildings that have building permits, and when is a building permit required? Well, a building permit is required anytime you construct, enlarge, alter, repair, move, demolish, or change the occupancy of a structure. So there's not a whole lot that you can do to a structure that doesn't require building permits. So once if you need building permits, the first step is you get plans drawn up and you submit them to the building department for review, and we check them for general compliance to the California Building Code standards. I think the key element there is that the plans that are submitted, they need to be drawn by a licensed design professional, such as a professional engineer or a licensed architect that has the expertise and knowledge with the ADA and the California Building Code, because essentially it needs to be designed to both standards, although all we're enforcing is the California Building Code. And then once we find out or we establish that the plans have general compliance, we issue the building permit. And then during the construction process, we perform multiple inspections during the whole construction process. And then at the very end of the project, we do a final inspection. And if the construction requires a certificate of occupancy, we'll establish or we'll issue a certificate of occupancy at that time. And it is illegal to occupy a building without that certificate of occupancy. So overall, everything is important to make sure that the building is compliant to the California Building Code standards and other health, life safety codes.
So I want to just go down that rabbit hole for a minute with you, Eric. So, you know, one of the things Josh talked about was access to the building, the parking lot, the ramp, what we call inside the building department or inside city walls is path of travel, right? How do people move around a site? Is that something that is looked at as part of the review process?
So the California Building Code requires that, look, if you have an existing building and you're doing alteration or an addition, that alteration or addition has to meet the California Building Code standards for accessibility, and the path of travel to that area, okay, needs to meet it. There is an exception. If that construction valuation is under $177,000, then only 20% of the construction valuation needs to be placed towards the path of travel. So that means that the area of alteration or addition will comply, but the path of travel may not have to comply to meet the building code's requirements. And we're only looking at the area of alteration and the path of travel. You know, there's other elements on the site or within the building that we are not looking at. And that's why, like I said before, it's important to hire a licensed design professional who can look at and has the knowledge of the ADA and the California Building Code.
Okay. And then, so if I come in with plans for a building or a modification, does the city require a CAsP, so a Certified Access Specialist report? Do we require that as part of a submittal package to us?
So there's no state law that requires that a property is inspected by a CAsP or Certified Access Specialist. You know, it's always recommended. In fact, anytime you pull a permit for a commercial property or even renew your business license, there's a flyer that you'll receive that identifies the CAsP program. It'll also give you the link to the Department of State Architect who oversees the CAsP program. And there's really good information on that website for business owners and property owners, and some questions and answers that are really informative.
Okay. And then, you know, I kind of want to get us a little bit more back on time. So I'm going to kind of use this maybe as the final question for you, unless there are others. So if someone does get sued and, you know, they're going through this process, this legal process, what can the city do in terms of helping them through this process in terms of augmenting? Like what would be your sage advice to them as they're working through a process on the legal side? How does the city help them maybe on the building side?
So you know, the only thing that we can really do is if you're in litigation, you know, we can do our best to expedite your plan review. And you know, our inspections are basically next day inspections. So we can do whatever we can, what's possible to expedite the plan review. You know, but once again, it really comes back to having a licensed design professional that knows what they're doing. Because unfortunately, I can't issue a permit on a set of plans that don't show general compliance with the, you know, California Building Code. And that could create a delay in the project because that would require, you know, me to do a plan review, write the comments, send them back, and then they have to resubmit. So really, I mean, the best thing you could do is hire a licensed design professional. And then once those plans are submitted, we'll do what we can to expedite the permitting process.
So, Eric, one of the questions that came up in the chat was, so what happens if someone builds a ramp not permitted? What's the city's position on unpermitted ramps?
Well, if you know, if we catch it under construction or we find out about it, we will issue a stop work order, and at that point, you legally have to stop work. until you obtain the necessary permits. Unfortunately, there's a lot of construction that happens in the city that we don't catch, and obviously it gets constructed. There's not a clear-cut answer to that. I mean, if we catch it, we issue a stop work order, and you got to obtain the proper permits.
Gotcha. I don't see any other questions in the chat. So I'm kind of done with my questions. If there's an opportunity to open up for other questions at the end, but recognizing time, and why don't we pause here, and Eric and I are available to answer any follow-up questions, and I'll pay attention to the chat. So thank you for your time, Eric. Really appreciate it.
Thank you, Eric. Thank you, John. All right, I'll go ahead and kick it over to you, Naomi.
Okay. Hello, everyone. I'm really sorry to hear about this happening again. I was part of the panel a year and a half ago and didn't hear anything until recently. And it's unfortunate due to the pandemic, a lot of the restaurants and businesses are constructed outside, and it's very difficult to try to comply with the ADA with all this happening. But there is a solution. All the business owners, please do yourself a favor. Open up your policies. Call your agent. Find out if you have what's called EPLI. The acronym of EPLI is Employment Practices Liability Insurance. And it all started from sexual harassment and discrimination 20 years ago. Well, with all the ADA coming up, we established, and other insurance companies established, a policy that will give you coverage for ADA. So what that means to you is it would be a preferred policy. It would have $1 million limit, and it would show that that punitive damages are covered under your policy. Punitive damages means third party. That means it's going to be either one of your vendors that comes by or management, so your customer, or someone from ADA coming in to inspect or try to go to the bathroom or order food or come visit your retail. Because we always see that retail and restaurants are the #1 susceptible to this situation. So with what Josh said is, definitely get an insurance policy. It's not that expensive. And a lot of companies, they don't know about this policy. And so, educate yourself, call your agent. Please call your agent. Call him today, her or him today, and discuss that coverage, because it will save you thousands, hundreds of thousands of dollars if you have this policy. And so that's my #1 recommendation today, is that you pick up the phone and call your agent, because they will know how to get this access for you and get it immediately. Most policies will have it separate from your general liability policy, but you can still access it. Some policies are better than others, so really look at it and make sure, #1 thing, if you're concerned about ADA, make sure it covers punitive damages, which is third party. Okay? I hope that was helpful. And if you have any questions, feel free to give me a call or, email me. I'm available anytime.
Thank you, Naomi. Does any part of that coverage cover attorney fees by chance, or is that?
Oh, absolutely. Immediate. The one thing is, the first thing you do is something like this happens, you contact your agent, submit the lawsuit, because farmers, then you can call Josh or whatever attorney you want. Farmers will then connect with your attorney and they'll work together. They don't want you speaking to this person. Once that lawsuit's filed, step back, because we'll handle everything. We pay for the response, because the response is, even if you're not guilty, you have to respond to a lawsuit, just like Josh said, and that could cost $4,000 to $8,000 just to respond, even though you're not guilty. So just, immediately just send it to your insurance company, and then whatever attorney you choose, or if you want the insurance companies to choose, let them hash it out, and you just step back. Oh, what is the policy called? From Jennifer. Jennifer, it's called EPLI, which is Employment Practices Liability Insurance. And make sure that when you do access or, ask about it, because there's other EPLI, which is you can get up to 50, 100,000, 250, but that's only for sexual harassment and discrimination. Key word is punitive damages, third party.
And is there only one policy level for that, Naomi? Is there like a standard one, or what if there's multiple?
Well, the standard policies are always going to be under $1 million, okay? Preferred is going to be the policy that's going to offer the third party punitive damage. That's key. So if you're not concerned about the ADA situation, then, and you're just concerned about sexual discrimination and sexual harassment, then you can just get the, you can get the lower amount. But I think that every company is open to, ADA coming in, asking to go to the bathroom or something, and you're not compliant, you're going to get sued. So.
Can you give us an idea, just ballpark range, whatever, of what that costs for the preferred?
Oh, you bet. For the $1 million, so it all depends on how many employees you have, obviously, because employment practice liability goes off of employees. So say hypothetically you have 5 to 10 employees and you want the $1 million of coverage, it's going to range anywhere from $2,000 to $5,000 per year. So it just all depends on how many employees you have. So the less employees, the less the premium. And you can always ask to minimize premium, you can always ask for a higher deductible. So you're not, if you say, hey, I want to go with a 5,000 deductible for the 1 million, it's going to reduce that premium. And I highly suggest that. I highly suggest going with the, higher deductible, minimize the premium.
Excellent. Thank you. Thank you very much. All right, Jim, you're up.
Good morning to all.
Good morning.
Thank you, Brittany, for letting me speak. My name's Jim Wilson, and my family's been in this beautiful city for close to 80 years. 9 months ago, my father-in-law got sued for the same thing, an ADA lawsuit. It cost him $50,000. And Josh, you're correct. Fast forward last month, my mother, she's 82, disabled, owns a little strip mall that's been closed down since January because of the COVID. And costs now, we've settled now at $20,000. And in my opinion, this is basically legal extortion. It's plain and simple, has really nothing to do with helping this disabled. What I've looked into this, these lawsuits, they've made these lawsuits so fine and so, what's the word I'm looking for, general, that there is a benchmark of cost, and that's all this is, it's cost. Josh mentioned how much it cost if you hired an attorney as himself, and it's unbelievable. And what's funny about this lawsuit my mom's going through is a little story. My mom, she calls me crying, and she says, I got these letters in the mail from all these lawyers that want to represent me on this lawsuit. And I said, Mom, what do you mean? Nobody served you any papers. Nobody's done anything. And she goes, I know. I don't understand this. And literally 3 hours later, somebody comes to the door with serving my mom some papers. So I go over there. I read the lawsuit. There's 3 violations. It's this Scott Johnson. And my daughter Googled him, and I believe he has like over 1,500 lawsuits at this time going on. So it is legal extortion. That's the only way I can put it. it took, when we looked at it and we hired a CAsP inspector, was $3,000. He came out, very nice man. He's in Morgan Hill. And he said, yeah, you need to do this. And literally, it cost me and my brother-in-law about $800 to do the violation. That's all. But the big thing is the lawsuit. And I hired one of these lawyers because we just pulled one out of the pile of lawyers, and the cheapest one could do it for $2,500. And I called my attorney and asked him, what should we do? And he basically said, if they can do it for that, go with them. And so we did. And it's just emails back and forth, and he's a go-between with this complainant. And it's a business. It really is. It has really nothing to do with disabled people, because my mother's disabled. And we wrote the lawyer that's suing us a nice letter, took some pictures to him, and basically she said, look, I feel your pain. I know you're disabled, but all you had to do was call us and we would repair these in a minute. And like I said, it literally took a day to fix these problems. But they don't care. They just keep sending us a bill. It's just a shitty thing. I asked for insurance. I looked into our insurance too. Even my mother has a $4 million umbrella policy, but it is the way that the suit is worded. And it states that he had mental anguish. And under my mother's umbrella policy and under the building insurance policy, they will cover any physical damage. They do not cover mental damage. And it's pretty shitty in that sense of the insurance. So our insurance will not cover anything unless it had to be more specific. The other thing what I was kind of taken back was the state and the federal, they don't care. They really don't care about if these lawsuits go through, because they get their buildings upgraded. But the person that gets taken advantage of is the building owner or the business. Like I said, my mom's 82. It's going to cost her $21,000, and it's just not right. And as for finishing this, the simplest way, but the state or the federal will never do it. All they have to do is require 90 days to fix the violation. Then 100% of these violations would go away. And these frivolous lawsuits, it's not right. So anyway, that's what I had to say, and I thank you for the time.
Thank you, Jim. Thank you for sharing that story. Do you want to talk for just one quick minute about the letter that your wife and yourself submitted?
Yes, my wife has submitted a letter to, who is our representative, Wasserman?
Yes.
And we have not received anything back. And she's in the process of sending a letter to, who's the other lady that, what's our other representative?
Zoe Lofgren.
Zoe Lofgren, yes. And basically saying, you guys got to do something about this, whether it's the state or the federal, but it's literally, they can do whatever they want. When asked, when I was talking with my lawyer and I was asking the question, because the lawsuit's very vague. They don't specifically say dates. they just say, we showed up January and twice in October. And we're put out because we couldn't open the door or we couldn't do this. But it's not specific. And when I asked for more specifics, because we do have a camera in the parking lot, and I wanted to check the dates. And this is where, Josh, this is where your attorney, the attorney we hired is very reasonable. It's $2,500. His job is, and I don't know him, his job is to move it along fast, settle, and get out. So when I brought this up to them and I asked for some more information so I can research the dates more, his response was, if you do that, you will open more and more cost. We need to just get this done and down the road. And that's all this is. It's just money. It really is. So.
Well, thank you for sharing. I know that's extremely difficult to talk about, and I think there's value in you sharing your experience with this group, with the attendees online. If there's any kind of parting wisdom or anything that you could share with anybody, kind of tips and tricks, we'd love to hear them.
Well, the only thing is, like what Josh said, get in, get it done as cheap as possible. Like I said, I hired this CAsP gentleman, very nice, did a perfect job. But this is another thing. I called my attorney and I said, look, I have these drawings and I have a certificate of compliance. And his response was, I don't need any of that. All I need is pictures showing that you've done the work. So the CAsP, it could have saved my mom $2,700 bucks. And like I said, it's a business between those lawyers. Like I said, Josh, I don't know any of the lawyers that sent my mother all these things, but my attorney and my friends that are attorneys, that's the way to go. Get the cheapest lawyer, settle it, and move on. Until something changes, that's what it is. That's going to happen. There's really nothing you can do about it. I thought it had to do with the state signing off on the ADA compliant, but it has nothing to do with. Nobody really cares. It's a business. There's this company down in Southern California. It's the Center for Disabled Access, which I don't know what that means, but their law firm is set up just to file lawsuits just like this, and it's very sad. So there you go.
Thank you, Jim. Thank you for your feedback, for sharing your experience. It's very valuable. Thank you, Naomi, for giving us some insight about insurance. Eric, some insight on the city building code side. And then Josh had to leave us, unfortunately, but I will send him a thank you just for sharing some advice with us and just what he thinks and what he's experienced. So if anybody has any other questions for our panelists, I did put their contact information in the webinar chat. So you can go ahead and grab that there. This webinar was recorded and will be posted to the Chamber Facebook page as well as the Chamber e-blocks on Monday if you are a part of that. So if you have any other questions, you can feel free to reach out to me, Brittany, BRITTNEY @morganhill.org, and I'm happy to address those to the panelists. Other than that, if anybody has anything else, we'll go ahead and wrap it up for the day.
Thank you. Have a great day.
Thank you, Naomi.